Good evening, everyone. I'd like to welcome you to our spring webinar series provided by the City of Los Angeles Department of Cannabis Regulation. My name is Frank Louie. I'm the Chief Operating Officer of the Cal Asian Chamber of Commerce, and I will be your moderator for today. Thank you for joining us this evening for a deep dive on the topic of contracts. This webinar, amongst other educational sessions, is part of the official launch of the Business Licensing and Compliance Assistance Program for the social equity applicants in the City of LA. The goal of this program is to help applicants obtain a commercial cannabis license as well as operate a successful cannabis business. Now, before we get started, let's take a moment to review some housekeeping rules for tonight's webinar. Please note that this webinar is being recorded and can be viewed after the editing process on DCR's website. You will be muted with cameras off for the duration of the webinar. This means that your camera and audio functions will not be available to you during this session. However, you will be able to see and hear all the panelists. There is an open chat box at the bottom of your Zoom screen where you can interact with one another for networking and comment on the information. Please use caution when sharing personal information in a public forum and keep your questions focused on tonight's topic. Encourage you all to please ask questions about tonight's subject matter in the Q&A box. We're gathering the responses to your questions throughout the presentation, and we'll leave 15 or 20 minutes for a robust Q&A session where you will get your responses during tonight's event. You are encouraged to utilize the Q&A box at the bottom of the pane on your Zoom screen. If you use the Q&A box for questions, everyone will be able to see the questions when they are answered. Finally, please note that the content presented tonight was not created by the Department of Cannabis Regulation or the City of Los Angeles and is for informational purposes only. This information is subject to change and does not replace or supersede the Los Angeles Municipal Code nor constitute legal advice. If you have any specific questions outside of tonight's topic, please call 213-978-0738 during business hours to speak to a DCR representative. Now, I am pleased to welcome Zachary Knox, tonight's subject matter expert. Zachary is the managing partner at the Knox and Ross Law Group and leads the firm's cannabis practice group. Zachary is considered an expert in this field and has spent over a decade advising and representing cannabis companies and entrepreneurs across California. In 2016, he was appointed to serve on the City of Oakland's Cannabis Regulatory Commission and continued to serve in that role through 2019, including serving as the commission's vice chair. Through his firm, Zachary has been serving as the contract legal service provider for the City of Oakland's Cannabis Equity Program since its inception in 2017. The firm has since contracted to serve other equity programs in the city of Fresno and San Francisco, as well as outside of the state. I've had the pleasure to collaborate with Zachary over the past couple of years on social equity initiatives. Without further ado, I'd like to welcome Zachary to join me on screen. Zachary, feel free to start sharing your screen and kicking off your presentation tonight. Thank you and welcome.
Good evening. Los Angeles Equity. It's such a pleasure to be here. Thank you for inviting me. We have quite a bit of material to get through tonight, so I'm going to jump right in. Tonight's topic is contracts. We're going to start with some general contracting concepts, slide right into some of the more common terms that you will see in contracts, and then we will conclude the presentation with some of the more common pitfalls the equity applicants have faced in contracting as they start their businesses. So without further ado, let's jump right in. So contracts, they're agreements, right? This is how we define relationships amongst partners, amongst commercial contributors. This is how we do business nowadays, right? And essentially an agreement requires you to do or not do something. And therefore the contract itself is an agreement to do or not do a certain thing, Okay, that's the basic concept of what a contract is. What you need to know, the significance there is that a real contract is ultimately enforceable by legal action. So that's how we're going to frame this. A contract is an agreement to do or not do a certain thing that is enforceable by legal action, meaning that you can go to a court or some other governing body and seek relief if the contract is broken, right? We can think of contracts as exchange of promises, right? Simple forms of contracts are often purchase agreements, right? I'm buying goods from you. I'm going to pay you cash, and that's the nature of our exchange. But it doesn't have to be a tangible exchange like that. It could be, I promise to do something in the future. In exchange, you promise to do something in the future. And that promise, those mutual promises, would be enforceable by legal action if we can get through all the elements to establish that there was a contract. One of the first things that we need to establish a contract is what we call consideration, right? This is the promise. The consideration is the value promised by one party that is offered in exchange for whatever that party is seeking. So that's the value proposition. There's something that I want, and you're willing to give it to me in exchange for something. It might be a promise, it might be payment in some form, it might be that I agree to take certain actions, or again, to not take certain actions. And the critical piece here is that in those exchange of promises, you value my promise and I value your promise, right? And that's where the consideration comes in. There has to be consideration, otherwise a contract is not going to be enforceable. So again, here's our example. This is the classic example of a value proposition and consideration. Person one is buying goods and person two is paying for them. So that thing of value that we're talking about here is the consideration that makes a contract binding. Now, what else does a contract need to be formed? There has to be an offer and there has to be acceptance. And these are sort of, what I would say is these can be intangible things, right? They can be sort of abstract concepts. What is an offer? Well, an offer is an express intention, right? I will give you X in exchange for Y. Clearly, what I'm looking for out of that exchange is the Y, and what I'm willing to offer is the X. I make that offer, I express that intention, and that meets the offer criteria for a contract, right? Acceptance, on the other hand, there has to be a formal acceptance. And if I make an offer and you, on the other hand, do not accept that offer, then no contract is formed. There has to be some form of acceptance. Now, obviously, this is real simple when we're talking about it in the context of written contracts. If both parties have signed off on the contract, then the presumption is there was an offer and there was an acceptance. Same thing in a traditional exchange. If I am selling goods and you're buying goods, I have my goods priced and you come to the counter and you pay for them, presumably you have accepted that offer. There needs to be offer and acceptance to form a contract. So here are some examples of what that might look like, right? A distributor offers inventory and a price list to retailers. The retailer then issues a purchase order to that distributor, and the distributor accepts that purchase order and delivers the goods to the retailer. This is offer and acceptance. The distributor made the offer by telling the retailer, this is what I have available, and this is the price that I'm willing to sell it at. And the retailer turns around and says, I will buy that product at that price. Here's my purchase order. Offer and acceptance has been established. The distributor delivers the goods to the retailer, and we have a binding agreement. I'm going to go through these kind of fast, by the way. Do contracts have to be signed? No, you don't necessarily have to have a signed written agreement. The example we just walked through, where the distributor issued a price list and told the retailer what inventory they had available, and then the retailer acting on that by submitting a purchase order is enough to establish that there is a contract. It doesn't require that there be signatures on it, although we will see in many cases having signatures on contracts can be important, particularly when it comes to enforcement. All right, so sliding right along, we're going to start getting into some of the more common contract clauses and provisions that you will find in just about every contract. Written agreements are still the most prevalent form of contracting. They're the easiest to enforce. They also have the longest statute of limitations period available to them. And what I mean by statute of limitations is if there's a breach of contract, you have a certain time window in which to act to try to enforce that contract. One of the advantages of written contracts here in California is they tack on about 2 additional years for a total of 4 under the statute of limitations, where on an oral agreement, your statute of limitations is 2 years. All right, so here are some of the terms that we're going to cover today. Recitals, exchange and consideration, the term of the agreement, closing, reps and warranties, termination, governing law and jurisdiction, federal waivers, dispute resolution, remedies, severability, notice, waiver, assignment modification, entire agreement, and counterparts. Man, that is a mouthful, but we're going to get through it. Recitals. Recitals are sort of how many contracts begin. They are the introduction to a contract. I think of them like this. They give the reader of a contract context about what the contract is about, who the parties are, and what the substance of their exchange is going to be. The recitals themselves, though, typically are not considered to be terms of the contract. Again, they're more of an introduction. And you may see archaic language like you see on the sample language here on the screen during recitals. You might have words like whereas or now therefore. In this example, what I want to point out is that the company in this recital is representing that they have substantial expertise in something. We'll get to representations and warranties later, but just because they say that in a recital doesn't make it actionable if at the end of the day you find out that is not the case. The recitals are really just the introduction to the contract. They are meant to give the reader context, okay? To that point, recitals are not typically binding. They're not part of the binding terms of the agreement. And that's probably the most important thing to note about the recitals. Again, the company has substantial expertise. This will be much more relevant when we get to representations and warranties, which are part of the binding terms of an agreement. The next part of the agreement that's really critical to focus on is the exchange itself. This is the value proposition that we brought up before. And your contract might be for goods, it might be for services, it might be for to bring in an investment into your business, it might be to engage employees or anything else that the business might need, right? So that's the substance of exchange. What does the business need? What is the business looking for? And what is it going to do to procure it? Whether it's providing services itself, whether it's paying capital, what have you. As long as there's an exchange there. And the part that you need to scrutinize critically is the exact nature of what you expect to receive. The goods, in this case, the goods or the objectives to be achieved and when, right? The deliverables under a contract are key. You need to know exactly what it is that you're getting, right? Oftentimes a contract will have objectives or milestones to it, particularly in the context of service contracts, right? So if you're hiring somebody to perform a service for you, it's going to be really important that you understand exactly what they are going to do, what you expect them to achieve, the objectives you laid out for them, and how they're going to hit those milestones. That's an incredibly critical part of the exchange that you should understand. All right. We often call these objectives and milestones deliverables. You may have heard me use that word a moment ago. Oftentimes, a contract may outline those deliverables in a separate attachment. It might be called a schedule of deliverables or a scope of work that is attached to the backside of a contract and is incorporated into the contract. That's very common. Whether it's in the body of the contract itself, though, or in a separate attachment, it's going to be critical that you understand what the scope of work is, what the deliverables are under that scope of work, and the specific objectives and milestones that are tied to those deliverables. You need to know what you're getting out of a contract. And again, we talked about consideration a little bit before. Most often it's a form of payment, right? Exchange for goods and services, liquid capital, cash even, if you will. That's the most common form of consideration, but it's not the only form of consideration, right? It could be that the consideration is to perform other services. The consideration clause itself should outline what that consideration is, but also how that consideration will be delivered. As you can see on the screen, that consideration clause, or it may sometimes be called a compensation clause, will specify a payment method, whether it's an installment plan, whether it's a discount that's going to be provided. All those things would be captured in that same clause under a contract. Another key clause is to understand the term of the contract. The important thing about a term is this is the period of time during which a contract is effective and in which the parties are expected to fulfill their obligations. We often think of the term of a contract as being temporal, a set amount of time, whether it's 6 months, a year, 2 years, but it doesn't have to be. In some cases, a service contract may specify that the term extends until the scope of work has been fully performed, right? So it's important to understand the term of your contract. And as we get later in the presentation, we talk about some of the pitfalls, we will revisit this concept of a term. Because the term could be broken down into an initial term and option or renewal terms. And if there is a renewal or option term, we're calling that a renewal clause in this context. These often give one party, or in some cases, both parties upon mutual agreement, the opportunity to extend the term further into the future. Again, we'll revisit this more when we get to some of the pitfalls that you should be looking out for. But for those of you who are not familiar, the initial term is, where the bulk of the contract is expected to be performed, and there may be additional terms after that, whether it's a renewal term, whether it's option term. Oftentimes, the initial term and the option term combined together is what we consider to be the complete term of the agreement. All right. So give you an example of when term is really important. In this industry, your license is tied to your facility, right? And so for those of you who are operating already or are just getting started and looking to operate, if you've identified your facility and you're negotiating a lease, it's going to be real important that you understand what the term of that lease is and what rights you may have to extend this lease. I often say that there's only one thing God's not making more of, and that's land, real estate. And real estate is super valuable right now in California if it's greenlit, so to speak, to house cannabis businesses. There are premiums that are being paid for that real estate right now. And oftentimes, as companies turn over, those lease rates and rental rates increase. I would recommend that everybody on this call, if you have the opportunity to do it, negotiate for a tenant option to extend your lease on your licensed facility. And what I mean by tenant option is a unilateral option on your side to extend the lease beyond the initial term if you so choose. That's going to be super important for your business, particularly further down the line as you consider an exit or you consider a transition. There's going to be a lot of value in your business if you can have extended lease rights as part of that value proposition. All right. We just talked about the ability to renew. It's really important that you understand who has the right to extend a deadline and when and how you have to notify that right to extend, right? We just talked about it being ideal that you have a tenant option relative to the lease on your facility. For those of you who are able to negotiate a tenant option, it's going to be critical that you understand when you have to notice that tenant option. Oftentimes, a contract may specify that you need to notice no earlier than 120 days before the close of the initial term, but no later than 60 days prior to close the initial term. They're giving you a window there in which you have to notify the other party that you want to extend. Okay, another key term, closing. And you will see closing a lot in investment agreements. The concept of closing is a deadline, right? There is some specific deadline that everything that needs to happen under a contract must happen by. That's the closing or closing date, right? The closing, and as it says here, is the process of closing out a contract, closing out an investment in the example that I gave. There is a closing date, which is the deadline that we just spoke about. But in that closing process, as I mentioned, we will be confirming that all the obligations of both parties have been met. And if we can check the box on all those things, then the transaction closes. For those of you who are out there trying to raise capital right now, or know that you need to raise capital, it will be critical that you understand the concept of closing. And when you read your contracts, to understand what the conditions around that closing will be. So closing conditions. This is each party's checklist for what the other party needs to deliver under an agreement, right? And oftentimes in agreements, the closing conditions are almost written as bullet point checklists. A, B, and C needs to happen before party one is obligated to close. And then X, Y, and Z needs to happen before party two is obligated to close. And by going through those closing conditions and observing that, then both parties can be confident that everything needed to be done to consummate the transaction has been done, and they can move forward. Representations and warranties. Typically in contracts, each party needs to make a representation and warranty about itself, right? These representations and warranties establish the trust and confidence needed for parties to move forward. Some typical examples, since we're all starting cannabis businesses on this call, is a representation that your business is duly licensed, or a representation that your business is duly organized and in good standing with the state of California. There may be a representation that you are current with your filings or with your taxes. There are oftentimes a representation made that you have the authority to execute the agreement on behalf of the company that you're representing, right? So we talked about certain representations that may be made in the recitals and how those representations and the recitals themselves generally are not binding. If there is a representation that's made in the recitals that is important for you, that your decision to enter a contract relied on a representation made by the other party, then you need to make sure that that representation is mirrored under these representations and warranties clauses. It's not sufficient that it was mentioned in the recitals. So the example that we previously touched on in the recitals, the company was representing that it had substantial experience in its particular area of business. If that is something that you relied upon to engage that company, then you want to make sure that that recital is restated under the representations and warranties clauses. Right. This is how you make those representations and warranties binding on a party. Right. So this is what I just mentioned. It's critical, right? Because parties rely on those representations and the warranties made by the other party. If they make a misrepresentation under those clauses, that could be considered a breach of contract. That's what makes it enforceable. Okay, so it's going to be critical that you scrutinize those representations and warranties. One, so that you know whatever information that you relied upon to get into agreement is falling in line there, so that if it turns out that that representation is false, then you have some enforcement action available. It's equally important that you scrutinize the representations and warranties that are written about you and your business. And if you're relying on somebody else to produce a contract, whether it's you're engaging a service provider and you're using their service contract, their standardized contract, you need to make sure that you pay attention to the representations and warranties that are specified about your own business to protect your own interests. Because again, if it turns out that those representations are not accurate, then you may have a problem on your hands. A classic example I can think of is somebody was buying a business and there was a representation that the business was operating in compliance with the law, that the business was current on all its requisite filings, the business had paid all its taxes, and the transaction went through, only to find out later that there was an inaccuracy in the tax filings, that the taxes weren't paid, and there was a lawsuit ultimately. And the company that made the representations at that time ended up having to fork over some money to cover the additional tax liability. It was literally a dispute about a breach of a single representation that impacted that business. That's how critical it can be, right? So here, again, here are some of the common representations and warranties that I just covered: that your business exists and is good standing, that you have the authority to execute the agreement, you're in compliance with the laws and regulations, and that you've made all the government filings and obtained consents necessary, and that you can perform your obligations under the contract. These are standard vanilla representations and warranties, but they may not be the only ones that show up in your contract. So it's going to be really important that you're focusing on those and that you're scrutinizing what they say. In this industry, I would not be surprised if one of those representations and warranties is always that you are maintaining a valid operating permit and/or state license. Again, this would be critical in this industry where everybody needs the license to play, let's say. And so I fully expect this to be a common representation and warranty for contracts that are used in this industry. All right, governing law and venue. Contract disputes arise all the time. I tell my clients, it's not a matter of if, it's a matter of when, right? If you're in business long enough, a dispute will arise. And so there is a need to define a process as to how to resolve it. I would say it's beneficial. The first is to identify what law you're going to use, right? And this may seem counterintuitive. We're all talking about California-based cannabis businesses, but you may have a software vendor that's based out of Colorado. You may have a consultant that's out of Illinois, right? And so you need to identify what law is going to govern an agreement. For those of you who are on this call, I think the answer is simple. It should be California law. We're all talking about equity businesses here. It should be California law. Don't subject yourself to the law of some other jurisdiction that you're not familiar with. Push for California law to govern all the contracts under your business. All right. Venue. Venue as a concept is where a dispute will be heard or resolved. Okay. And that could be, in this case, Northern California, Central California, Southern California, any county in California. Because we're talking about the city of Los Angeles equity cannabis businesses, again, I think the answer is real simple here. Los Angeles County should be your county of venue, period, right? You don't necessarily want to have to trudge your way all the way up to the Bay Area to fight a lawsuit in the Bay Area because you happen to get into a dispute with a vendor in Northern California, right? For all your contracts, try to have venues set in your home county. And we'll get to ADR here in a second, but if we're looking for alternative dispute venues, we can narrow that down even further. It could be the city of Los Angeles is where we're going to have a mediation or an arbitration held. But if we have to rely on the courts, those are typically governed county by county. So the answer is simple for everybody on this call. Your venue should be LA County, unless we're getting into ADR, and then you can drill it down even further. Okay. Federal law and the waiver of it. I'm sure everybody on this call is already aware that cannabis is federally illegal, right? And I won't get into the nuance on this webinar of, what provisions there are in federal law that allow state-sanctioned cannabis businesses to operate. But the bottom line is, it is still illegal to conduct cannabis business under federal law, right? The significance here is because cannabis is federally illegal, that creates a defense if you want to claim that somebody breached your contract. In summary, they will essentially be arguing, Judge, you cannot enforce this person's contract because they're engaged in illegal business anyway. To get around that, we need to have a waiver of federal law. It's going to be incredibly important for all of your contracts, particularly for contracts with parties that are not engaged in the cannabis business themselves. There should be a federal law waiver in all of your agreements where the parties are waiving the illegality of the cannabis business as a defense in any contract dispute. It should be in every one of your contracts. If there is resistance to that, don't do the deal because you can't protect yourself. Insist on there being an inclusion of a federal waiver, at least in regard to the cannabis business and the illegality of it under federal law. All right, so what you're seeing on the screen now is an example of what this federal waiver might look like. And didn't get to highlight the salient points here, but if you go back and look at this, once the city has it posted on its website, you will see in pertinent part that each party is waiving any defenses based on illegality or invalidity of contracts for public policy reasons and or the substance of an agreement or definitive agreement violating federal law. Basically, we don't want anybody to turn around and say, you can't enforce your contract because you're engaged in the cannabis industry. So insist on this being part of your contracts. It's super important. Okay, so we just talked about governing law and venue a minute ago. And in that discussion, we mentioned that under an ADR scenario, you probably could drill down venue even further from the county level to a municipal level. ADR stands for Alternative Dispute Resolution. Courts tend to favor parties working out their disputes outside of court, whether that's through mediation, whether that's through arbitration. Courts tend to favor that. So it's important to consider having these provisions in your contract as well. Generally, litigating in court is an expensive and timely process. And the idea behind ADR is not only efficiency and adjudication of disputes, but oftentimes you can get faster relief. Oftentimes you can get relief at a less expensive price tag. And so it is almost ubiquitous now that these sort of provisions are in all contracts. But again, the value of having an ADR provision in your contract is that it helps you avoid costly and time-consuming court battles. Here's another example of what an ADR provision might look like. And what's important to note here is that what this provision is providing is that any claims that arise, out of this agreement will be settled by final binding arbitration. So there's not even the possibility that this ends up getting litigated in court. There is only one method of settling the dispute here under this agreement, and that is to go to final binding arbitration. There are some other provisions that you might find in a contract that also helps reduce the cost and time involved and the risk associated with extended court battles, right? And what we're looking at now are liquidated damages and limitations of liability. So for those of you that are not familiar with the concept of liquidated damages, this is where the contract attempts to put a price tag on a breach. A liquidated damages provision may provide a specific dollar amount of damages should a particular party fail to meet its obligations. It could be as simple as any breach of this agreement, you're going to pay us $10,000. That is at a very high level what a liquidated damages provision might look like. It's literally a term that obligates a breaching party to pay the non-breaching party X amount of dollars. The idea here is if a party knows that there is a specific price tag hanging over their head in case they breach, they might be less likely to breach. They might be less likely to resort to the "will take me to court" response. Here's an example of what a liquidated damages provision might look like. Well, I was really conservative here, $500. But what's important to note here is that upon a breach, one party is then obligated to pay another party. And that's what a liquidated damages provision is all about. It brings certainty around the damages. Another method is limiting liability, right? Limiting liability sort of goes the other way. It caps the amount a party can be required to pay if a contract is breached. And similarly, here's an example of a limitation of liability provision. The concept here is that if there is some astronomically large risk of extended damages, then parties might not get into an agreement. And we want parties to get into an agreement. So a limitation of liability sets a cap on what damages may be. Oftentimes, we need to scrutinize that cap and make sure that cap is reasonable, but it's not uncommon to see this in a lot of contracts. It provides certainty around what the outcome will be if there is an eventual breach. Indemnification. Indemnification is another common provision that we'll see in contracts. What indemnification attempts to deal with is there are typically one or two parties that are engaged in a contract. And that contract may contemplate that some outside third party brings a claim against the parties on account of the conduct taken or the conduct exhibited by one of the parties as they perform their obligations under the contract. So I know I sort of made that mealy-mouthed and wordy, but the idea is the conduct that we're expected to engage in under the contract may possibly result in third-party claims. And how do we handle third-party claims if that takes place? And that's where indemnification kicks in. The indemnification provides protection to one party in the agreement for problems that are created by the other party that impact third parties, right? So that's probably a better way to describe it. For you, indemnification should be mutual, right? And it might be a series of indemnification provisions. It might be one indemnification provision that has mutuality in it. What we're seeing here is a sample indemnification provision that provides protection against not only a party, but it's also its directors, officers, managers, advisors, employees, contractors, volunteers, and affiliates, right? And it protects them from liability against other indemnified parties, and protects them and other indemnified parties from liability for action that the first party was taking under the agreement, right? This is sage advice. Make sure to include everyone associated with your business in this indemnification provision. So you heard all the titles I just read off. Party B, its directors, officers, managers, advisors, employees, contractors, volunteers, and its affiliates. As broad as possible, because oftentimes that third party that's bringing the claim may not name just party A or party B. They might name an individual employee. They might name the CEO of the business. They might name the business's contractor. And so that indemnification provision needs to be broad enough to encompass anybody that claimant might bring a claim against. Right, and here's the example I just read off twice. I think it's also important to note that your indemnification provision should spell out a broad range of potential liabilities, right? A narrow indemnification provision is almost useless because then the claim would have to fit within that narrow provision to be actionable. Here's an example of the sort of broad language I think is appropriate for indemnification provisions. Party B and its indemnified parties are held harmless from and against any and all claims, judgments, damages, liabilities, settlements, losses, costs, and expenses, including reasonable attorney's fees and disbursements. And it defines all of that as a loss, right? So that's what I'm talking about when I say broad range of potential liabilities. Severability and waiver. Okay, these are also two common provisions that we see in just about every contract. Severability. Severability clauses ensure that even if a particular portion of a contract is held invalid, then the rest of the contract remains in full force and effect. Without a severability clause, there is an argument that if a court were to find any part of the contract invalid or unlawful, that the entire contract would then have to be thrown out. The significance of this clause, though, it allows the parties to say, well, even if the judge struck one particular clause of a contract, the rest of the contract still fulfills the intent of the parties, and the rest of the contract will remain in full force and effect. Um, Oftentimes, a severability provision may outline a method for replacing or correcting the portion of the contract that may be held invalid. And so what you're seeing on the screen now is some sample language to that effect, right? If any provision of this agreement is determined to be void or unenforceable, that provision shall be deemed limited to the extent necessary to render it valid and enforceable, and the remaining portions of the contract shall be construed and enforced so as to best effectuate the intent of the parties. Now, you may see different language in another severability provision, but the key thing to note here is that in addition to holding the rest of the contract as valid and enforceable, this severability provision went a step further to sort of create a scenario about how the parties would handle the specific part of the contract that was struck. And the way they're choosing to handle it here is to come up with a method that best effectuates the intent of the parties. There could be other methods, but the idea here is that we want to keep the contract as enforceable as much as possible. And if there's a chance that the severed provision is critical, then we have language here that helps effectuate the interests of the parties. Waiver clauses, on the other hand, means that any failure to insist on exact compliance with certain terms will not impact the enforceability of a contract. So I think an easy example of this would be if you're renting space in your facility and you're paying your landlord rent every month. Well, rent might be due on the 1st and late on the 5th, right? But let's say that you're hurting for money this month and you're not able to pay until the 10th. If your landlord accepts the money on the 10th, the question could arise, did your landlord waive the right to receive money on the 1st and late by the 5th if they accepted money on the 10th? And I guarantee that your lease probably has one of these provisions in it, so that even if the landlord were to accept your rent late, they could still turn around and insist that the next month they're paid on the 1st, and the month after that they're paid on the 1st. So they call these waiver provisions. I like to think of them operating more as a no waiver provision, right? They're essentially saying we are not waiving our rights because we have failed to insist on exact compliance with the terms of the agreement. And the language that you see over on the right is also an example of a sample of waiver language. Okay, so we've gotten through some of the general terms of the contract and some of the basic contracting concepts more generally. We're now going to dive into some of the areas where we often see pitfalls for equity businesses that are starting up. In this section, we're going to cover some of the organizational management and governance of your business. And we're going to cover management service agreements. Right? These are two common sorts of contracts that most of you may have to deal with at one point or another. So organizational structure and governance. There are many considerations for formalizing your business structure, right? You need to consider the capital contributions that your partners or investors are bringing in, your participation in management, your right to distributions and preferences, and then buy-sell provisions. These are the things we're going to cover here in this section. Okay, so capital contributions. Capital contributions are the assets that the members or owners of a business put forward to finance a company. Traditionally, those capital contributions are made in proportion to each owner's interest in the business, right? However, the equity segment of this industry has sort of turned this on its head. An equity business license may require that the equity qualified owner control more of the business than they can finance. I believe in Los Angeles, there is a 51% requirement that the equity holder holds 51% of the business. And by definition, equity qualified individuals tend to be under-resourced. And so they've created this dynamic where an equity qualified business owner is limited in how much of the business they're able to sell to bring in the requisite capital. Obviously, if you have to maintain a 51% ownership interest, you're limited to selling up to 49% of the ownership interest. This is where a lot of equity operators have ran into trouble trying to capitalize their businesses. And it's not the fault of the equity operator. I largely point the finger at the investment community, who has a certain way of doing business and is slow to transition and slow to adapt to the requirements of participating with equity partners. What you see on the screen is often how the investment community looks at equity. They interpret it to mean that the equity partner gets 51% of the business for nothing, while they're expected to put up all the capital in exchange for something less than a controlling interest, right? For those of you who are already operating or already trying to raise capital, this may be something that you've ran into or likely will run into, right? So this perception of this disparity in financial obligation is what drives much of the questionable and predatory behavior in this industry, which is why we're talking about it here today, right? So some of the pitfalls that you need to be on the lookout for, right? If, let's say, you're able to secure the investor and they're willing to put up the capital in exchange for a 49% stake or something less than that. Oftentimes, you will see them try to recoup that through predatory terms in your governing documents or in your investment documents. One of the first ones I want you to be on the lookout for is future capital calls. This is where the capital partner says, well, I'll put up the money on day one, but they're reserving the right to come back later and ask you to contribute money to the business, right? These sort of future capital calls have been used to squeeze out equity qualified partners. And what you're seeing here is sample language. It's a sample for you, but this has come from a real agreement that my office reviewed. It required that members be willing to make additional capital calls as needed. The problem is it also wrote in a consequence if a member failed to make that capital call, right? And in this contract, the defaulting member had their interest in the business held at risk, right? You won't see all that language here, but essentially, if a member failed to make that capital call, they were going to treat that as a debt against that member, and they were going to use that debt to offset distributions that would have went to that member. And I've even seen cases where a member's voting participation in the business would be suspended until they're able to make that capital contribution. So this is an area I want you to be really critical of as you look at your agreements when they're presented to you. Do they require you to make additional capital contributions in the future? Does the business reserve the right to do that? And if you are unable to do so, does the governing document create a consequence for you? This is what I mean when they say they've used additional capital calls to squeeze out the equity qualified participant. So differences in capital contributions are often used to justify reduced influence of the equity partners in favor of other capital partners. And this brings us into the concept of management participation and whether or not you will have control or even a meaningful opportunity to participate in directing your own business. We're going to get into management participation at a number of different levels, but I think what's key for you to know as you look at these agreements is to make sure that you fully understand what your role will be at the ownership level and at the board level, right? We're not talking about employment at this point, and I know some of you may be employed as officers or managers of your own business. But what we're really going to scrutinize today is your role as an owner and your participation at a board or manager level. So at the ownership level, the key consideration in terms of management participation is your vote, your owner vote, your shareholder vote, your member vote. As an equity holder, you should always have the right to participate in management at the ownership level. Anything that gets escalated up to a shareholder vote or a membership vote, you should be participating in, right? Some of the rights reserved for owners and evidencing the need for you to be able to exercise your ownership vote. As an owner, you'll be electing the board members. As an owner, you'd be expected to vote on the authorization and the issuance of new ownership interests. This is another way that predators try to squeeze out their equity partners. I've seen situations where the capital partners want to reserve the right to authorize and issue new equity securities. That has a dilutive effect on you as an equity holder. Now, that may run into complications if you are already diluted down to 51%, which is your minimum. But I would also caution that, typically at the beginning, you own 100% of your business. And you're bringing in partners oftentimes to raise capital. And that's okay. It's okay to dilute, but you want to be sure that you have participation in that decision. If you decide for yourself that dilution is what the company needs and there's enough room in your equity stake to dilute without hitting the minimum, then that's a fair decision to make as long as you are knowing and informed and have voted on. The ownership also needs to approve certain major transactions, whether your business might merge with another business, or whether you might sell the business, or whether you might wind up and close down the business. These are examples of topics that should be dealt with at an ownership level. They're really critical for your business. And so you should ensure that you have and maintain participation at the ownership level. Be aware and be wary of any contract clauses that limits your ownership rights. Some of the gamesmanship that we've seen around that is allocating a different class of stock to the equity holder, and maybe that class of stock has a disproportionate amount of voting rights. And you can see sample language on the screen right now of exactly what I'm talking about, right? Class A has 10 votes for each share. Class B has 1 vote for each share. In the contract that I pulled that from, equity owners were allocated Class B shares. The other level of management participation you should be really scrutinizing is board level participation. For a corporation, a board of directors is required. They oversee the business at a high level and delegate operational authority to the officers of the business. For those of you who are thinking about opening an LLC or have LLCs that you're running, LLCs can establish a manager or even a board of managers for the same purpose. And again, that manager or the board of managers could delegate operational authority to officers, but they are charged with oversight over the business on behalf of the owners, right? This board or management role is often the most significant level of management in the business, right? They are charged with overseeing day-to-day operations, and anyone else who is running the business actively has had their authority delegated to them by the board. So please note, carefully review your role in this layer of the organization. It is not unheard of that capital partners try to exclude their equity qualified partner from participating at board level, or will try to make sure that they have a disproportionate amount of control at the board level. Now, most owners with any significant interest should maintain direct representation at the board or manager level. That includes folks who are listening in on this call, right? If you have a 51% stake in the business, you need to have direct representation on that board, period, full stop, right? And this direct representation could be accomplished through certain voting rights, or it could be accomplished through appointment power. Beware of any contract clause that places undue limits on your power or options in this board context. Some examples that we've seen are equity applicants only receiving observation rights when it comes to board meetings, or the expectation that the social equity applicant will serve individually on the board, even if they would prefer to nominate somebody to represent them who may have more experience. And then again, allocating voting power that is significantly disproportionate to the interests held by the equity operator. I'm not suggesting that it has to be in direct alignment here, but if you're a 51% owner and they have 90% of the board vote, that is significantly disproportionate and probably should be viewed as predatory. All right, owner distribution rights and preferences. This is another area in governance documents where we see a lot of predatory behavior. So closely examine these clauses that provide for distribution rights and preferences. Distributions and dividends, for those that are not aware, are how owners get paid as owners, right? I'm not talking about if you're also working for the business and getting a salary as an employee. I'm talking about your compensation as an owner and how you receive it. They're called distributions in LLCs and dividends if it's a corporation paying them out. These are typically paid out in proportion to an owner's percentage interest in the company. In most other industries, that is exactly the case. If you own 51% of the company, you're going to get 51% of the distributions when they're announced. That doesn't always happen in cannabis specifically. We see a lot of preferential treatment. Capital partners may insist on preferential treatment. And in an industry that doesn't have access to traditional capital markets, you may need to acquiesce and allow for some preferential treatment, right? Disproportionate allocations to capital partners are not necessarily predatory, right? If I'm putting up all the money for the business and I have a 49% stake and you have a 51% stake, I may say, hey, for the first 5 years, I want to get 60% of the distributions. And if we can agree that that's a reasonable offset for me coming up with all the money, then that preference may not be predatory. That being said, distribution preferences are one of the easy ways that capital partners can come in and try to take some predatory action. The question you should ask yourself if you come across a distribution preference is this preference reasonable? And if it is reasonable, then it may be justified. But if it's not reasonable, if I'm asking for, 90% of the distributions into perpetuity, I would consider that to be predatory behavior. But just because there is a preference doesn't necessarily make it predatory. That's why we have to look at it really closely. So when you're evaluating it, here are some other questions that you can ask yourself to determine whether or not a particular preference is predatory. How much capital is the partner investing? Is it going to be equity capital or debt capital? Do they bring other valuable resources beyond just cash, whether it's their network, whether it's equipment, whether they have real estate that they can contribute, whether they have specific expertise in the licensed activity that you're engaging in? How disproportionate is the preference? And does the preference ever sunset? And by sunset, I mean, does the preference ever end? Be aware of any clauses that require 100% return on investment before distributions are made, or otherwise places a dollar cap on your participation in those distributions. Buy-sell provisions and liquidation preferences is another area that we need to scrutinize to ensure that you're not falling victim to predatory behavior. So a buy-sell provision outlines the terms under which one owner can buy out another owner. And a liquidation preference, similar to a distribution preference, specifies how the assets of a business will be distributed if the business is liquidated, such as in a dissolution. Again, reasonable disproportionate allocations can be okay, but you need to analyze them very carefully, right? Establish terms for these scenarios, because having these terms can be useful if the relationship sours. Oftentimes when these business relationships start, everybody is going through the kumbaya, right? Everybody is happy. Everybody thinks it's great. Everybody expects success. And then the money starts coming in the door, or worse yet, maybe the money doesn't come in the door and the relationship turns. Good luck at trying to build agreement around how to handle it after the relationship has turned. It's better to set these things up in advance so that you can have a smooth transition if the relationship sours. But because they establish how that will be handled in advance, you also need to scrutinize these provisions to make sure that they're not predatory in nature, right? So beware of provisions or preferences that places a cap on the price that a partner may buy you out at, or places a cap on your participation in any distribution of assets when a business is liquidated. So here's an example of predatory language here in a liquidation preference. So in this scenario, if a company were to liquidate, they would pay their debts and liabilities and the expenses of liquidation. They would set up a reserve, and the remainder would be as follows: to Class A members, in accordance with their percentage interests, up into an amount equal to their priority return, and then to members to the extent of any unpaid capital contributions. And it looked like they cut off a portion of this, but the C under 3C would have been to Class B members, capped at, I believe it was $125,000. So you can see that this sort of language, although ostensibly could be for innocent purposes, right? To decide how we're going to handle things if the situation were to arise, but specific language in it could create could make the provision predatory. Management service agreements, and this is the last part we're going to get through. Oftentimes in this industry, management service providers come in and help you run the business. Large MSOs who might invest in your business often require you to sign MSAs to receive their capital. In exchange for management, they're looking for fees. They're looking for options to extend the term and to terminate based on performance is an issue that we'll need to deal with. And balancing the liability limitations and indemnification provisions that we discussed previously are going to be key. Questions you should ask yourself: do they have retail management experience, warehouse and management logistics experience? Are they filling other gaps that your business needs? We have sample alternate language here for management service providers that you could take a look at. For management fees, the management fees are their consideration, and what you really need to evaluate is the actual realistic costs of retaining that provider. They may charge a flat fee model, which can be dangerous if the business does not earn enough money to cover their fee. They might also charge you in a percentage of revenue model, which can be risky if after all expenses paid, there are no profits left to distribute to the owners. So here's sample language for both of those fees. MSAs can be beneficial, but you must be really careful with the fee structure and the terms because such fees can be predatory. Pay close attention, as we discussed previously on term agreements, the options to extend, and think about your ability to terminate that MSA if the manager turns out to perform poorly for your business. All right, again, we talked about term. We know what that is. MSAs commonly contain options to extend. We talked about those options previously in a lease context where you wanted to ensure that you had the option to extend. Under MSAs, it's typically the management company who is seeking to have an option to extend their services. Be really careful about that. You may need to preserve the right to terminate that agreement if necessary. As I said, which party has the option is really critical here. Beware of anything problematic like the provider having the unilateral right to extend the term, particularly if there's no ability to terminate the agreement for poor performance. So here's a sample language of what that might look like. All right. We're running short on time. So in the case the provider has a unilateral option to extend, as I said, a terminating provision for poor performance is highly recommended. I just can't reinforce that enough. Here's sample language that you might use to establish that. And then balancing liability limitations and indemnification obligations. We've talked about limited liability. We've talked about indemnification already. Make sure that those interests are balanced, particularly when a provider is performing direct services. And when you bring in that person into your business, their actions may open you up to risk. You can insure against these risks, but insurance may not be adequate. So again, limitations on liability and indemnification obligations will allow you to shift which party is carrying the burden of that liability. Providers in this industry will oftentimes try to avoid it. Okay. So again, here's another example of preferred indemnification language for MSAs. Understand that this will be available to everybody. If you have additional questions, please contact the DCR at dcr.sep@lacity.org or dcrlicensing@lacity.org. Thank you for the presentation time. Thank you for joining us. I think we're going to open it now for questions.
Zachary, thank you very much. It's always a pleasure to work with you on developing content. Great job, great information, and your ability to make it digestible and understandable is invaluable. So we appreciate working with you, and we went over intentionally. It's hard to pack that in, and even the amount of time that we did. So, but great, we got through it all. And just to let everyone know, this will be available on the DCR Learning Management site that I think most of you are aware of. So to be reviewed at a future date or re-reviewed, as well as some additional content that we'll continue to work on as well to cover these topics. So thank you. There were some great questions. There were several questions, and I want to ask a couple of these. I know Darwin had sent one in earlier. I don't know how familiar you are with the City of LA's landowner attestation form and the requirement for the landowners to sign an attestation form prior to operating in working on putting a lease together that confirms that there was no illegal cannabis activity performed at the site, previously. And Darwin's question was, should I sign a lease agreement before the landowner signs the landowner attestation form?
My feeling is that you need to vet these properties, and you need to vet your partners, including your landlord, right? So I think there's a diligence process that goes around securing commercial real estate. As part of that diligence process, you should be inquiring what prior use the building was put to. I think it could be very reasonable to have the landlord sign that attestation form before you sign your lease agreement. A lease agreement, however, is typically one of those agreements that does require signature of both parties. And so I don't want to go as far as to make it sound like you need the landlord to sign the lease agreement before you do, but I think there could be a tremendous amount of wisdom in having them sign not only the landowner attestation form that the City of Los Angeles is requiring, but the state of California also requires a landlord attestation, or a property owner, attestation that you are authorized to occupy and use the premises for cannabis activity. And I would not sign a lease without having that authorization. So I think what Darwin is suggesting is probably best practices.
Mm-hmm. Agreed. Thank you for that clarity. Edward also asked a good question. I don't know the context behind it, but an investor is assuming all the risk and the equity partner risks nothing. Can an agreement be considered unenforceable or some other technicality because of this?
Well, I think the first thing I would respond to that is challenging the assumption that the investor is assuming all the risk. Very rarely have I seen in this industry a scenario where the investor assumes all the risk. I would venture to say that that sounds like an investor speaking. Look, as they try to get a better deal for themselves, they will oftentimes try to downplay the contributions made by equity and the value that you are bringing to the business. Look, your participation in the business is bringing resources to the business. Your ability to participate in forums like this. In some jurisdictions, your equity qualification will have your business eligible for financial resources, which are contributions to the business.
Yes.
I believe in Los Angeles, they are still only issuing equity licenses to stores, which means that there is no participation. There is no other game in town right now except equity. And so that is bringing value, right? The fact that there is an ability to secure a permit and secure a license brings value. And what I hope everybody can leave here today feeling is that you are a valuable contributor to the business yourselves. Don't let the capital partner belittle your contribution to the business and start having you think in the framework of you're not at risk. And you're just as much at risk. This is your opportunity just as much as them. They may be taking a larger financial risk with the money that they're putting up, but you're taking other risks yourself. Some of you will be asked to sign personal guarantees on real estate. That's a risk. So I just want to challenge this notion that the capital partner is the only one taking risks here. And to your specific question, I believe it was Edward who asked this, would the contract thereby be unenforceable? No, the contract is still enforceable. Whether or not somebody is at risk is not really a consideration in assessing this. What they're really going to assess in terms of the enforceability of the contract is, was there an offer? Was there acceptance? Are the parties competent? And was there consideration?
Yeah, great. Thank you. Very thorough. I'm going to ask these two final questions. Even though we're over time, I think it's really important to capture and get this, kind of, captured in the video. Zachary, what about mistakes? Does a mistake in a contract affect its enforceability? And we've seen lots of mistakes out there. Not intentional, unintentional, but mistakes, right?
That is a great question. And I'm going to have to give you a very nuanced answer. In short, maybe, right? The question becomes in the analysis is, was the mistake mutual or was the mistake unilateral? If you are the only person who made the mistake and everybody else didn't make the mistake, chances are the contract will still be enforceable. But if both parties made a mistake of fact, then the contract could be held void. So it's really important to identify what kind of mistake. Is it a mistake of fact? And is the mistake mutual?
Yeah, great. I'll ask this last question. Again, I know there's a lot of situations out there in the social equity community throughout California, certainly in the city of LA. What is a breach of contract, and what should I do if a breach occurs?
Yes, important question. A breach of contract occurs whenever one party fails to meet its obligations under the contract. It could be as simple as you didn't pay on time, or you failed to pay, but it could be as complex as some of the things that we discussed in the presentation, like a misrepresentation or a warranty issue that could constitute a breach of contract. I would suggest that if you think there was a breach of contract, consult with legal counsel. And I believe that DCR has a local bar association down there on standby. get in contact with somebody, with some legal counsel to get advice on it straight away. Don't let the matter linger. And be ready to talk out the breach, right? Don't knee jerk resort to the nuclear option of going to court. Oftentimes you'll get a lot further, but just reaching out to the breaching party and saying, hey, let's talk about this. Let's negotiate and see if we can't come to a better resolution.
Agree. Well said. Well said. If there are any other questions that we weren't able to get to, we'll circle back. Love to try to get responses to everybody. We appreciate everyone staying on. We certainly went over, but for a good reason. Great content, great information. Hopefully, we've enabled you with additional information to support you and help you on your journey. Zachary, thank you very much. As always, I look forward to the ongoing development of more content and education as we move forward. Thank you all for attending this informative webinar offered by the City of Los Angeles Department of Cannabis Business Licensing and Compliance Assistance Program. This webinar's recording will be found on DCR's new learning management system portal, where you can access these online courses and digital resources made especially for you. As a reminder, to access the LMS system for the first time, please visit the URL. I think they'll drop that in the chat, or you can certainly go to the DCR website, logging in using the email address that is linked to your DCR Excella account, and use the temporary password, password1. After your initial logon, and the system will ask to create a new password that you will use moving forward. There are hundreds of hours of content there to help you on your journey. If you have any questions on accessing your account, please email dcr.sep@lacity.org. Before signing off today, don't forget to fill out the survey about your thoughts on this webinar. The link to this survey is dropped in the Zoom chat box. You will also receive an email with the link to the survey following this event. Your feedback is critical and important to help us continue to develop great content and educational material for the community. So please take the time to fill out the survey. For more personalized support and answers to your questions, we continue to offer free virtual cannabis business advice on a one-on-one basis. These sessions are on Zoom on Fridays from 12 to 5 until April 29th. The next session is tomorrow. There's a link as well that you can log in to register for that. And also, I know it was mentioned in the chat a couple of times, please contact the DCR or the website www.cannabis.lacity.org to inquire about the pro bono legal services provided to certain eligible social equity participants. This is an amazing resource that's available to those that are eligible, and I encourage all of you to tap into that to take advantage. Our next event is Tuesday, March 29th, again at 6 p.m. to learn about the business of cannabis delivery with subject matter expert Robert Fierro. Thank you again for joining us. Have a wonderful evening, and we will see you all at our next event. Thank you.